This is very interesting because now I'm thinking about all the accounts that I have, of which there may be some, and I'm now thinking, do I have any open that are still only in my name? And I think there's one. I'm double checking right now.
Which one?
We have good estate planning lawyers, Nathaniel, if you want to sit down with them and start.
How much is in it?
Damn it. Ying's already on my case. Shoot. It is just in my name. Yes. A whole $12.94.
Welcome to Critical Thinking Required, hosted by LBW. This podcast is intended for free thinkers, entrepreneurs, and knowledge seekers. Join us as we discuss relevant financial topics, explore with guests their financial journeys, and engage with experts in industries such as space, media and entertainment, real estate, and many more. Buckle up and enjoy the ride.
Welcome to Critical Thinking Required. You're with your hosts, myself, Tim Bickmore, and my two colleagues, Dan Weiss and Nathaniel Leach. And today, we are going to talk about a personal household merger. What do we mean by that? We have a lot of conversations with our clients lately, and they say, hey, we're getting married. How should we combine our finances? We have people who go into second marriages. How should I handle this combination going into a second marriage? We actually have this conversation a lot more than you'd expect from older generation to younger generations, and we want to talk about it. So before we jump in to our topic, and Nathaniel will be captaining our ship today, have one note to state, which is, if you love our podcast, like what we say, please share, subscribe, and like all of our stuff. It would be very appreciative, and it really helps us out, so please do that. That's all I have to say. So Nathaniel, please kick us off.
Hey, Tim, you're missing your white shirt. You didn't get the memo.
Obviously, I wasn't on that text chat, so thanks, guys. Appreciate it.
I mainly just want to set Nathaniel into song, because I think it's just a nice way to. It's a light night podcast for us. I feel like it looks like a little bit like Grease.
Fine. Go grease lightning, you put it on the wheel, yeah. Grease lightning, go grease lightning, go grease lightning, you put it on the wheel, yeah. Grease lightning, go grease lightning, you're supreme, supreme, grease lightning.
Now we're ready to begin.
That's where we're ready to go.
So, as Tim said, this is about the personal household merger. So, as Tim also mentioned, we come across this a lot. Different strokes for different folks, as we like to say, or as I like to say personally. Everything, it works differently for everybody. Everybody is unique in this aspect. Every partnership is unique. So today we're going to really dig into what we've seen, what the so-called standards are, like how to think about it. What are some laws? What are some concepts that you should be aware of? And just see where the conversation takes us. So I'm just going to kick it off. I'm going to toss it into the air and see which one of you decide to bite. So the question is, to combine or not combine?
Oh, I'll start it off, Dan, because you're going to get into some of these technicalities. I know it. So I'll start with the big picture. That is a good question. Combine your finances or not? I don't think there's a right answer. It's what would you like to do, and then understanding how to execute on it and what your expectations and objectives are really what it comes down to, right? With our questions, it's always never a black and white. It's always a gray, because it depends on what the household's trying to achieve and how they want to function. So as I mentioned in the entry to this podcast, it's you may be coming into a second marriage, could be a third marriage. You may have gone through a very difficult divorce, financially speaking, and maybe you just feel like you want to have that independence. Maybe you just don't want to have to combine finances. I think that's an okay answer. I think another answer to that too is saying, I want to continue to combine my finances regardless. But what Dan and I really try to promote is understanding why you want to do it, how you should go about it, and what techniques are out there, or even laws out there that can help facilitate some of that independence or the combination of your money with a partner with ease. And I think a lot of people just don't necessarily understand how you can go about it in a very confrontational way with your partner and have an open conversation to achieve each other's objectives. So to combine or not combined is the question, but it also isn't where you should start either.
Yeah. And sometimes too, it's not even just usually like what Tim is saying, it's because someone's going to get married, or maybe they're not going to get married, but they and their partner just want to combine stuff because they don't need to get married, but they feel like that's something that they do. It could be even something outside of partners. Like we had a conversation last week with somebody who got joint title, which we'll talk about in a second, on a mortgage, right? Or I should say deed for a house. And so she's joint on her primary residence with her dad. It's not his primary residence. The week before, I recall having a conversation with the client, right, who was considering being joint credit card holders with their daughter because she couldn't get approved for credit, right? Or last week we spoke with another client who was looking to become joint, right, with his brother who needed a cosigner for a loan. Why do I bring these situations up? Because they're combining finances, right? Doesn't necessarily mean that you have to be a partner. You're still combining finances. So this comes up all over the place. As Tim mentioned, we could start with some technicalities. First thing to understand, besides the real big question, which is do what you kind of want to do, right? In fact, before I hit the technicality, like for example, and I'm sure we'll get into this, my wife and I, we have basically separate liquid finances, but we're joint on this house. We have a couple of joint accounts. I don't even know if she even realizes that actually, because she just is like, hey, do this and just keep me informed, which we'll talk about too. But it shows up in different ways. You've got to do what's right for you. There is no book on this. Now, going back to technicalities. Because there's no book in it, you do have to understand a couple things when you get into it. So rights and responsibilities. If you make somebody joint on your account, it means they have every right and responsibility to the funds inside that account. So if they wanted to, they could take that account and they can drain it, do whatever they want with it. If it's a joint account, you have no legal recourse for that. So understand that, right? If take the situation of the daughter and the client. Now, this particular person has a very responsible daughter that they're putting on the credit card. But if that person forgets to pay a bill, it's affecting your credit, right? If they run up the card, you're on the hook to pay it. If that client's brother doesn't pay the loan, the bank is going to go after him just like he were that brother. They don't see you as anybody different. There are also some, we'll call it benefits, right? For example, I shouldn't say benefit. This is a terrible situation that I'm going to then try to spin here. Somebody passes away. Somebody becomes incapacitated. If you're joint on that account, you can assume those assets and take care of whatever has to be the case. You can also title things differently, right? You can have things that are singly titled just in a person's name. That can create some issues too that we'll talk about at some point in here too. You can have things that are titled tenants in common, where in a sense you kind of own like shares of that particular account, and that can make a lot of sense too. But how those assets pass are different. If we're talking about an account that is jointly held by a party, again, rights of survivorship means that party takes over if that other party isn't there. Tenants in common, not necessarily the case. Whatever that share is probably passes to somebody else, or else they maybe would have had a joint to begin with. Tim, Daniel, anything you want to add about that? We'll talk about coverage here in a second.
I actually have a follow-up question to that, Dan. This might be too detailed, but for a joint account between people who are either not related or are non-spouses, how does that work if one of them, how does that work in terms of contributing to the account? And if one person dies, like in terms of the estate exemption, like what is it, 11 plus million per person today, and it's going to reset to 5 and some odd million in 2026. How does that all work?
So if you're looking at joints with rights of survivorship, I'll step in for Dan to answer this question. If you, for example, I'll use my example. Let's say my brother and I are on a joint account and we have $100,000 in that account and I pass. He assumes that account. My rights of it, right, don't go to, let's say, my spouse, or if I had children, or go to my parents. Tony is the 50-50 joint owner on it, and he will just assume that account and that money will be his. Now, it would have to be on his own fruition.
Tony, your brother.
Yeah, my brother. Thank you. So he would have to go ahead and say, hey, my nickname is Scooter. Scooter's, everyone, if you listen to our podcast, you'd know that. Hey, Scooter's spouse, here's 50 grand, and would have to then gift it to her. So that's how it would work with anybody that you're on, regardless if it's a spouse, if it's a brother, if it's a stranger on the street. You are going into that account as if you are complete owners of it, both 50-50. So from an estate standpoint, that money would then be given to him. So if I was over the limit, sure, you may have to potentially pay gift taxes on that, theoretically. Most people probably aren't above that if you're on a joint owner. If it's a spouse, it works completely differently, completely different when it comes to an estate plan. But for a sibling or a stranger, it could work a little different. But most people probably don't have enough money in a joint account with a stranger to have to worry too much about it. Tenants in common, he would not receive that 50 grand. It would then go, as Dan mentioned, to my next of kin, a spouse, whoever's in my lineage, essentially.
Can I build on to Tim's lovely answer to that too? This is not the question you asked, Nathaniel, but tailoring that question to what if that happened if it was a married couple? The other thing to consider is the law that sits inside of your state. So, for example, what I mean there is that there are 9 community property, also known as marital property states. In fact, 8 of them touch each other in some way. 1 does not. The one that does not is Wisconsin, where we sit. But the other 8 you'll find on the West Coast. I don't think I'd get them all, but Texas, New Mexico, I think, Arizona, Nevada for sure, California for sure. I believe then Idaho and Washington. I may have missed 1 or 2 there. But in states like that, it is assumed that with a spouse, whether we're talking about basically divorce, usually when we're talking about marital property, but everything in the account is split 50-50. That's the assumption right off the bat. Of course, that can be negotiated, but in the other states outside of those 9, you're dealing with a common law practice. The common law practice is going to really refer to what that person came in with, how they basically, whether it's through different legal arrangements, dice up their assets. It's not assumed it's 50-50.
The lawyers decide, Dan. The lawyers decide.
The lawyers win. That's right. So yeah. So just to tailor that a little bit, so I think that kind of covers a lot of that gamut. Moving on then to the coverage piece of it that we mentioned, the other thing to consider is your titling. This goes hand in hand, is the FDIC limits on your coverage. Which I'm happy if someone else wants to jump in to talk about that, but pretty much it's $250,000 per a registration.
Yeah. So could you guys go into some detail about what is a registration versus, say, an account? Like, what's the difference?
So a registration or a title of an account is what matters. And what that is how it's literally titled on the account. So we'll use Nathaniel as an example. Nathaniel has an individual checking account. He is the only person in receipt of said account. That means that would be a registration or a type of an account. It's an individual. You can also have a joint account. So I'll use Dan and I as an example. Dan and I could have a joint account together where we are both on the account. That's a different title or registration of an account. You can have a trust account. That trust account would also be different because it's a different entity in itself that can have that account. And then the beneficiaries would technically then be insured. So depending on the title or the registration of the account is then how the FDIC insurance is covered. So sometimes people get confused where it's like, well, I only have $250,000 to be covered by. And they think usually it's per institution. Like you have $250,000 at Chase, $250,000 at Citibank. That's not the case. I could have an account by myself, an individual, insured at $250,000. I could have a joint account with Nathaniel, so that we both would be insured $250,000 or $500,000 for that specific account. I could have another joint account with Dan. However, that may affect my joint account registration amount with Dan specifically. Or I could have a trust account, which then that trust account could be a whole different type of coverage insurance. So it's about what title and the registration. Dan's laughing because I may have messed that one up.
No, it's confusing, right? It's just a confusing, It's a confusing thing. So it's registration, and it is tied though to the individual institution. So for example, if you start maxing out your FDIC coverage at one institution because you have put some things in trust and you have some things joint and you have some things from an individual standpoint to get past your 250, you could do that. At some point you hit a wall there. And so how you then avoid that wall is then you step out to another institution, which actually doesn't have to be the case necessarily. Institutions do have programs, and the name escapes me off the top of my head, but where they can actually share coverage. So you don't have to have multiple institutions. So you could have, let's say, we usually see this with like CDs, back when CDs would pay better than what they pay now. You can place a CD within your institution to go over that coverage. And what's happening is the bank is then basically buying a CD from another institution. So they're like borrowing, if you want to say, coverage. So there are ways to extend that and still keep to one. Or you can open up something elsewhere and then boom, all of a sudden you've got all these registrations that can start over again. So there are things you can do, but obviously eventually, as complicated as this sounds in verbiage, becomes just as complicated in real life because you have assets all over the place.
So does that cover you guys on the FDIC? Okay.
I think the point being that you should make sure you're covered, and your bank can also go through that too. They'll have better flow charts than us to figure out, are you covered and are you not? And you should ask that question if you're unsure.
Right. Okay, good to know. So then moving on in the discussion, can you speak a little bit more about like what kind of convenience factors should you be looking out for as you're thinking about how to structure your accounts at various institutions, and then in partnership with either by yourself or with other people or your spouse, or how does that all work?
I think convenience, it's like anything else. Convenience comes with pain, and pain comes sometimes with convenience. When in the sense that you can have multiple institutions, right? I mean, in today's world, with all of the really interfaces and being online and online banking, it's probably a lot easier to manage multiple institutions, to be able to spin things up, fund an account. It's all electronic. I don't have to go into a branch, sign paperwork, do all that stuff. You can just kind of spin it up online really quick. So that, which is nice. But the reason why I say sometimes convenience can cause pain is you think then you can open up many accounts, fund a bunch of accounts, and then you lose track of it. All of a sudden you have multiple things, people forget about it. A partner comes into your household, they have a whole different institution. You start going to that institution. So convenience creates almost like a paradox of choice. It's like, oh shoot, I have so many choices. What do I choose? Which can become a problem in my mind. I'll be very honest, probably for the listeners / viewers, I am probably projecting my own anxiety over having multiple accounts. That's just the way that I function. So I can understand when people want to use it for different mechanisms. The envelope theory, right, is what you could really build out. But sometimes having that convenience can cause issues if you're trying to really sit down and understand what you have, put it all together, and manage it, right? Because in theory, it sounds cool, but you also have to execute on the theory, and that's where people typically fail. And it can become really hard. The other piece to it too, what we see is when people start combining finances for the convenience, is that they switch up their method of management of the money in how, like inside their household. So, you know, picking on Nathaniel and Ying, let's say that they decided to combine finances, and Nathaniel is very specific about how he manages his account. And he pays, you know, certain bills go into it. He pays it. Well, all of a sudden now money's combined, And Ying manages her money completely different with multiple accounts. And all of a sudden you start combining those two, or you extend yourself, and all of a sudden you get lost in the execution of managing your money. And sometimes that can lead to some financial missteps or some financial mistakes. So the convenience is nice. I think we live in a very convenient world, but I think you also have to take convenience with, there's always a pro and a con. And the con is that you can get kind of lost in the day-to-day management, or until you at least get in the swing of things. I will tell you, most people, they want to consolidate, and they'll consolidate to fewer accounts just because it gets overloaded. But Dan may have a different opinion than me, so I'll let him go.
I mean, it's probably the largest motivator when people start talking to us about combining accounts. Outside of the fact that maybe they think they're supposed to because they're considering a joining of official union. But I think Tim speaks very eloquently that sometimes it becomes a bigger nightmare than what it's worth. And sometimes it's not the case. I mean, there are definitely reasons to not combine. Convenience is a motivator, but there is a benefit perhaps to having an account that is, used for gifts, that you can't see what is happening in there, or that you don't want to see. We have many people that where one of the partners perhaps has a separate account of fun money for them to do things they enjoy that their partner might think are really dumb things. And it's, psychologically speaking, better for the partner not to see those things, even though they know they're occurring, right? It's kind of like you figure out what to allocate, you dump into that account, and if it's blowing on lollipops or whatever be the case, then that's what it's blowing on, and you figure that money's already gone. That's a little bit harder when you have a joint account because you see it. So it's constantly a reminder of, God, that's a problem. So again, this goes back to what we say really kind of, works. Is it good to have those talked about things separate because of that? Are there not? Another place too that stepping back that makes sense is maybe combining things from an estate planning standpoint don't make sense. Maybe we're shifting off money because we're earmarking something that we don't want to get combined, whether it's legal stuff where if the money is joined together, it's going to be considered perhaps part of that union and therefore divided that way, or maybe it's earmarked for a particular reason. So convenience is a huge motivator that sometimes can create some issues. We would say, I think all three of us would agree that convenience alone is not the way to go ahead and make a decision like this to combine finances, although it definitely is a consideration. By the way, I'll add too that there are other ways to get convenience built in to your account without having to combine them. You can indeed draft up power of attorney documents, or have specific limited power of attorneys attached to specific accounts. And what that would do is it could give somebody else access to those funds without making them joint. The effect might be exactly the same to do so, but mentally maybe that provides something different. Maybe it's only for a period of time and then it disappears. It's just another avenue, but keep in mind that that does give that person all rights and responsibilities to that money. The other designation that we can see from a convenience maybe perspective is a POD or a TOD, transfer on death, or payable on death. These are designations of basically sticking a beneficiary on these assets. So if somebody were to pass, that beneficiary can prove who they are and step in and receive those assets. Because we will definitely have people say, well, I want someone joint on this account because if I pass, I want it going X, Y, and Z. It's not the only way to do that.
Fascinating. So I've had some questions and thoughts that have popped up in my mind. I'm just going to hit one for now. But if you're trying to, how does that work with community property? If I wasn't yet married and I had a separate account in my name, obviously, so long as it stays in that account, it's considered separate from the community property. But then what if, as I'm married and I get married and then a year in, and then I set up a new account in a separate name, or I take that same account and I start putting money into it and it's only in my name. How does that work?
So I think what you're really talking about is what is considered commingling of funds. So at least within the state of Wisconsin, as Dan mentioned, a community property state is a 50-50 state. However, even where our generation's going is we're getting married later in life, which means we've started our career, we've probably built our own assets, we have things going on, and we didn't get married at 20 and built it together in a sense, right? So if you're getting married 30, 35, and you're structured in your career, you may have built these assets up. And so you may have these individual accounts like you're talking about. And so what can happen though is if you get married in the state of Wisconsin and you still have this individual account, but let's say that your spouse or your partner makes good money too, and you start contributing money into that account, right? What the state of Wisconsin is going to do is they're going to say, well, now you've commingled these funds. These funds are now commingled. So now they're part of the marital property, which means now they're going to be split 50-50. And you may have built that account up for the last 10 years without any, anything that's to do with your partner or your spouse. So you have to be very, very careful about what is considered commingled. Now, Dan and I have talked to lawyers about this, and the idea of commingled funds can get argued in very specific ways. So it's like you got to be kind of conscious about it. So when we see people who really just want to say, this is my asset and I do not want this to be part of the marital, that's where you can do estate planning work where you can say, this is marital property, have the spouse sign it stating, hey, this isn't my property, this is my spouse's property, and then making sure that you don't commingle it anyway, because I've heard that it could theoretically be argued that even if you're together and you're earning interest on it at the time when you're married, like, is that considered, commingled property, things like that. So it's very important that if you're serious about it, that you got to take it serious to make sure that you set up the appropriate mechanisms not to commingle that fund. Because once you do, it's a 50-50. Now, if you open up an account while you're married, right, that could be considered marital property because now you guys have combined finances post-marriage. That's going to be considered commingled, like marital property, unless you physically state that it's not. So
wait. Open an account in whose name? Your name?
Even if it's in your individual name, but you're married, because it's really the date of marriage. I believe, Dan, you can correct me if I'm wrong there, states that that's kind of the date of the start for a community property state. So you get married, you open up your own individual account, your spouse does, that's still going to be considered marital property because you've been married post opening that account. It's anything prior to marriage where you can start excluding it. However, there may be the ability again to write in a marital property agreement stating that account is not yours, it's mine. So, but that doesn't always fall in line either, as Dan mentioned, with other states. There's only 9 states, like Dan said, that follow those types of estate planning mechanisms or rules or laws. So that's where you just have to be very cautious on where you live and then what your objective is. That's also a really, really important piece is like, do you want to go through all that hassle for a $50 checking account? What's the asset? What's the meaning behind the asset? What's the objective? How do you want, is it going to cause strife? Do you just sign up prenup? What does that look like? You just have to go down some of those bigger rabbit holes and figure it out.
This is very interesting because now I'm thinking about all the accounts that I have, of which there may be some. And I'm now thinking, do I have any open that are still only in my name? And I think there's one. I'm double checking right now.
Which one?
We have good estate planning lawyers, Nathaniel, if you want to sit down with them and start.
How much is in it?
Damn it, Ying's already on my case. Shoot. Well, and another good.
More than $10.
So I'll bring this up because I think this is the only account that you would think that maybe is only yours, which is your Roth IRA, which you love. I know I'm saying you love your Roth IRA. But let's say it's a 401k and you get married. 401ks do state the spouse has to sign off if they are not the beneficiary. They have to remove themselves as a beneficiary from that account specifically. So that's another thing too, that sometimes when you get married, that's a big deal on a 401k where you have to have spousal consent not to be the beneficiary of that account. Your IRA made me think of that. Your Roth IRA made me think of that. That's the one account that you'd want to keep to yourself.
You have to.
No, she's already said she's getting it if we divorce. So I'm screwed.
You've
Oh,
done
it
so
is
well
just
with
in
that
my
over
name.
time.
It is just in my name. Yes. A whole
You're the child
$12.94.
Dan, did I miss anything on that specifically for that
but-
question?
No, it was an account I opened before I got married. So according to what Tim just said, if she hasn't put funds into it,
Then you made
Well-
contributions to that
I'll
account while
open
you were
already
married.
tomorrow.
Yeah,
Yeah.
that's the thing is if you've been married and you've made contributions and it again you have to it gets very
Ooh,
technical.
Wait a minute, wait. You're telling me if I have an account in my name that I opened before I got married, and then I got married, and then I made a contribution into that account from, say, my paycheck.
Chris, commingled funds because you
Commingled.
used marital property, used funds.
Marital
earned in the-
income.
It wasn't marital income. It was my income.
We'll
because
let
we
you-
say
we'll
on
let
our
you
tax-
figure that one out after the podcast.
No, wait. No, I'm onto something here. So if we file taxes separately, does that matter?
Nope, that's a taxation issue, not a legal issue.
Son of a gun.
What are you trying
She's
to
got
do?
you.
Hmm?
Don't
What are
worry,
you trying
Ian,
to
you're not
find
gonna
out?
get away with it.
Damn it.
So yeah, I'm glad
tried.
you brought that up as an example though, because that is commonly thought that that's the case, but not in those 9 states. Now that's a different story perhaps in a common law state, but we don't
Got
have to
it.
get too deep into there. We're not
Yes,
attorneys.
I've-
We spend a lot of time with them.
I've already gone down the rabbit hole too far. So with that, I think that we should switch to more of the qualitative. So
Okay.
in that regard, I think that it would be good to switch to speaking to the importance of awareness with both partners or just by yourself of all of your accounts, where they are, to Tim's point, executing on said accounts. This runs the gamut from checking accounts, savings accounts, credit card accounts, mortgages, student loans, having an idea of where everything is, and then communicating that if you have a partner, communicating that with your partner. This also should go for business partners, as far as I'm concerned. You should be
Any partner. Yeah.
absolutely go.
Thank you for taking the time to start your journey of thinking differently and listening to LBW talk about stuff they love. Until next time.